Okay, well, albeit for a somewhat select audience, it's my very great pleasure to welcome Stephen Schulhofer, Professor of Criminal Justice Law, largely, at New York University, here to the Lauterpacht Centre. I noticed in your biography you've written on many issues to do with privacy, particularly from the perspective of the Fourth Amendment, it seems to me. But your most recent book is very much looking at this issue in a sort of transatlantic perspective. And here in Europe, we've had so many issues connected with that, going back to the debates over the Safe Harbour Agreement, but much more recently, obviously, the Snowden revelations, Schrems, the cobbling together, if you like, of the Privacy Shield, and then potentially the threats to that with the challenges, again, from Max Schrems, and also, obviously, with various things coming out of the White House under Trump. So without further ado, it gives me very great pleasure to welcome you and your talk on cross-border challenges to data privacy.
Thank you very much. Thank you. The most recent thing coming out of the White House was that Trump accused GCHQ of spying on him. Did you see that? That was just this morning.
Mm-hmm.
So here was sort of like my topic, although I don't give a whole lot of. It's not really relevant to anything. I think what he said, but it's just an example of how crazy things get. But anyway, thank you very much for having me here. The topic, as you know, is the way that globalization has impacted primarily law enforcement, national security, intelligence gathering, and the right to privacy being the underside of that. So as I worked through this, I noticed, and just speaking to you and your students just now, that in so many ways the American perspective is completely the opposite of the Europeans, and including the UK. You would think that in so many ways we share common values and common assumptions, certainly compared to the rest of the world. And the American legal system is so much, if not identical, certainly very, very close to the British one. And yet, in terms of privacy, so much of the American attention is focused on government powers to intrude on data or any other sort of private information. That was, in a way, that was the, I'm ad-libbing here, but thinking about it, I mean, this is why we are an independent country more than anything else, because the writs of assistance, and I don't know if this is common currency for those of you who study data privacy and things like that, but in the 1700s, the big issue was the taxes on tea, and the writs of assistance were kinds of warrants, but they were issued by the Secretary of State to search warehouses for untaxed tea, black tea, not marijuana or anything like that. And that has been ascribed in many sources as the precipitating cause of the American Revolution. So our history, as well as current practice, litigation, court cases, legislation, everything is dominated by focus on restraining government authority to intrude on private information, originally people's wills, records, files, things in their persons, houses, papers, and effects is the language that we use. And the private sector is kind of ignored in all this. And in American law, the private sector does whatever it wants. The assumption is that people are free to negotiate whatever terms that they want. And when you see the privacy terms that you have a little box to check, the theory is if you don't like them, you can negotiate your own version of them. I mean, it's crazy, but there's no legal framework, virtually none, and I'm exaggerating, but by European standards, it's non-existent. The relationship between a customer and the ISPs is entirely a matter of contract and private law with no public mandates or framework whatsoever. And when I look at the European side of this, although I know people are interested in government powers and so on, but all the litigation and all the controversy and all the focus of concern is on the access to data by private sector institutions. And certainly much more realistic understanding of the fact that these privacy agreements are not something that people can voluntarily accept or reject or tweak to their own satisfaction. And conversely, relatively little attention to restraining the powers of the government. Are leading, even in Britain, you have warrants to conduct a search, including just a physical search as well as data searches and things of that kind. The pinnacle of protection is when the warrants are issued by a Secretary of State, supposedly under some sort of articulated standard. That's precise. If you look at the American cases from the 18th century, that was precisely the bone of contention, because the Americans, the Secretary of State is an instrument of the government. At that time, it was Lord Halifax, who was the principal offender signing these warrants, and the American Fourth Amendment grew out of absolute unwillingness to accept that a government official, even someone as high up as the Secretary of State, could have that power rather than a judge. So in a way, this is by way of introduction, and I hadn't really planned to go into it. I'm almost triggered by our conversation because I'm realizing something I was aware of before, but bringing home to me that so much of our preoccupation, both in terms of our attention and the materials, the litigation, the cases, the legislation, everything. It's all about restraining government power and not at all about the private sector. Whereas here, and you read Digital Rights Ireland and Schrems and the decision, relatively new, the Watson case. It's all about the private sector, really. The court talks about, well, I think in Watson, the court talked about the fact that there weren't well-defined limits on government access to the data, which begins to sound like the kinds of things that concern Americans. But it also had this really remarkable objection to bulk retention of data by the private sector itself, which would be kind of unheard of, or unknown territory for Americans. So let me, with that 15-minute introduction for a half an hour talk. And again, to try to bring you into my frame of mind and thinking about what restraints on the government. Actually, this is another introductory thought that I had, I think, in reading about Watson, and in reading about you folks must know David Anderson.
Yeah, to some extent.
David Anderson is I guess the commissioner, the oversight commissioner for investigatory powers in the UK, and a point that he underlined was that there's a relative degree of trust within the UK and in Western Europe, a relative degree of trust in the integrity of the law enforcement services, which is different because of historical experience from the attitudes in the East. Most especially Germany, of course, but even the new members of the EU from on the East. And he reads Watson, I believe, he reads Watson as, in part, growing out of that greater degree of mistrust that because of historical experience that you have in Germany and the former Soviet bloc. At least I think that's his effort to try to understand where the court was coming from in that second branch of its decision, the criticism of bulk retention in the private sector. So drawing that contrast in historical experience between the West and the East, and thinking about the U.S. and we're really much more like Eastern Germany in our historical experience, or in our view of what our historical experience was, our perspective on it is really much closer to, if David is right about that split, and about a spectrum of, along a spectrum of trust, mistrust of the government. We are much closer to East Germany and the Eastern Bloc than we are to the UK. I would love to have David Anderson overseeing our system, but the fact, legally it would be utterly unacceptable because he's not a judge. He's appointed nominally, appointed by the Prime Minister. That would be a complete non-starter in the U.S. frame of mind. So with that, thinking about this in terms of very high level of mistrust of the government, the preoccupation is government overreach, government intrusion into privacy. And one reason I think that's important is that I wasn't planning to articulate for us why privacy is important. It goes without saying. But I think, when we think about privacy, primarily, not only to enable personal growth and self-actualization and creativity and everything else that's valuable in human beings requires a robust shelter for people to develop themselves, but also as a very much connection to freedom of expression and the right of dissent and to criticize the government. So for us, the right to privacy is very much linked to democratic values of a free society where people are free to dissent, to criticize the government, and that without a shield between individuals and government intrusion, democracy itself is no longer viable. So that underlying value is a big part of why we see privacy as a question of individual versus the government, rather than individual versus the corporations. So in the last century, I think, as you would all know, legal safeguards for privacy vis-a-vis the government, again, were very incomplete, to say the least. But on a practical level, they were pretty workable because people had lots of ways to shield their privacy from the spying eyes of the government. You could talk to people in person. You wouldn't record it. You wouldn't post it online. Telephone conversations were actually pretty safe because they were evaporated immediately unless they were being recorded in real time. And you could always keep sensitive documents in a drawer in your home, and they were safe, subject to a search warrant. But the digital communication changes all that because files concerning your health, your finances, your travel, what you buy, what you read, aren't stored anymore in the house. Usually they can't be. Even your medical records are stored in the files of hospitals, banks, ISPs, or even in the cloud. So people have lost the physical ability, never mind the law, people have lost the physical ability to shield their private lives from spying eyes of the government in particular, but anyone else for that matter, as hackers as well. And at the same time, government spying has become exponentially faster and cheaper, not just legally, but even in logistical terms, because you don't have to send out a SWAT team of armed agents to break down a door and dig through people's file cabinets. Some single person sitting at a desk with a few taps of the finger can pull up all of that information. And in addition, when you get the information, it can be probed for links and patterns that are invisible when you have the same information in hard copies. You can't possibly analyze a stack of hard copy information the way you can data. So all of that poses an unprecedented challenge to private life. And then the legal safeguards have eroded also. and this is where the cross-border issues come into play, because information can be accessed from places that have almost no relationship to the nationality of the people who are affected. So government agents can search in another country without ever having to set foot there. And our CIA, and I'm sure they were doing all kinds of things, but CIA had an enormous budget, but still there are practical limitations on how much spying you can do when you have to send out human beings to travel to Bulgaria or wherever it is, or Cambridge, England, which becomes just simple when you're just sitting at a desk in Washington or wherever you might be. So that erodes legal safeguards. And then in addition, and I think this is one of the most important, neither the US, the EU, the UK, or any other nations that I'm aware of extend privacy protections to foreign nationals outside their own borders. So the US can spy on Brits, and GCHQ can legally spy on Americans. I don't think they spied on Trump. In fact, I think your government already issued a statement saying it was absurd, which it is absurd. But legally they could. That means that people can lose the privacy protections vis-a-vis their government, not only of the country that conducts the search, but also of the country where the search occurs. There's a kind of a black hole with no law providing any protection. And then on top of that, you have all of these loopholes, or cracks, if you will, in the wall of privacy protection. All of the are compounded by cooperation between the intelligence services and the magic of what we call incidental collection, which you may know what that is, but I can talk about it. I'm a little hesitant on many of these subjects because I think many of you know this area as well, and in many ways probably better than I do. So I don't want to bore you, but also I don't want to use shorthand that's not familiar, so interrupt. I'll say a little bit about incidental collection, which I think is very important. And again, I keep realizing that how much I'm obsessed with the government, with the CIA and NSA, and are they looking at me? And it sometimes seems to me that Europeans aren't worrying about that, and it surprises me, but it seems like they're worrying about what Google is looking at you and what Facebook is looking at you. Is that right? I think, well, why on earth do people care? And the reason it's important to us is because the government uses that as a lever. They take it as a given that Google knows everything about you. That's a given. It can't, it's unquestionable to the American mind, because private corporations are good. That's just, a given. And then they say, well, if Google can look at it, why shouldn't the FBI be able to look at it? The FBI is trying to stop human trafficking, child pornography, terrorism, all of these things. And if Google can look at it for trivial purposes, why shouldn't the FBI be able to look at it for existential threats against the country? That's the argument that they make. And I guess I'm not the only one on any of these issues, but this is one of the issues where I've probably been more vocal than other people in trying to explain why it's a world of difference between Google knowing things about you and the FBI knowing things about you. True, the FBI has more at stake, but at least to me, it seems that Google can, offers you stuff that you don't want to buy, and that's really annoying. I don't know if you've had the experience. If I book a flight to London, within a couple of minutes, I get a pop-up about hotels in London, and that's annoying. And the first time I gave my credit card to a taxi, and he said he was going to send the receipt to my email, and I said, well, I have a long last name, so I have to spell it. I said, it's okay, we already know what your email is. what? That's really annoying. Just from my credit card, they already had my full email address. That's annoying. But it's only annoying. It's not like the FBI knowing things about you and knowing whether I participate in Occupy Wall Street or what radical groups I may be meeting with. Google can't put you in prison. It can't indict you, which in the U.S. anyway is a catastrophe for most people just to be indicted. So all the things that to me make this government looking at you is just so infinitely more concerning than what the private sector might do with my data. That's part of this obsession. I don't know if I'll persuade any of you to get interested in control the government side of this threat.
If we look at that from a European perspective, what seems surprising is that nevertheless we see decisions like Schrems and subsequent decisions which appear to suggest that practices which are legal in the States to do with bulk retention of data and lack of access to that data and lack of transparency of that data are in fact illegal under European privacy law.
Yes.
So in fact an alternative hypothesis possibly would be that Europe just cares a lot more about privacy than the United States and takes a more comprehensive approach, but that also means that often public sector activity is scrutinized with more, say in Germany, with more restrictions than
in the US.
I mean, maybe the UK is the outlier there to some extent.
But Germany also has that history, and I don't know German domestic law. What I recall from my expertise, such as it is really with U.S. law, and the little that I've followed in the Strasbourg Court and the European Court of Justice jurisprudence. But even there, I think even in Germany, my impression is that oversight is by parliamentary committee and things like that. They don't have the same tradition of requiring, as far as I know, ex ante approval of every single search by an independent judge based on probable cause. And you don't have that in the UK, well, as you said. So if you might be right that maybe the European system is more comprehensive in that it shields privacy not only from corporations, but also from the government. That may be true, but it seemed to me that, and maybe it's just an artifact of what's been litigated, but it seemed to me that there's relatively little attention to the threshold prerequisites for the government to collect the data itself. We can talk, maybe we should talk, we could talk more about that. I'm wondering about that, but it seems like some of the concern about data retention in the private sector is because government can get access to it, right? And the court has expressed that because whatever's being held is potentially accessible.
And the Digital Rights Island case was about government mandated retention of data for up to 2 years.
Yes.
In order for it to be made available in relation to serious crimes. So
because,
to say that isn't state action, I think it clearly is state action.
Oh yes, right. No, you're absolutely right. I mean, the state is mandating the private sector to retain it. In a way, that's argued the fact that the state is mandating it is a distinction without a difference in a way, because all these companies retain it anyway. They want to retain it for their own, at least in the U.S., they want to retain it in terms of their business model. That's why one of the reasons why the transfer, I guess it was, the Safe Harbor Agreement is so important, is because all of these companies want to transfer the data, so they use it for their own commercial purposes. They want to digest it and all. They don't mind keeping it. So at least from a U.S. perspective, mandating it is a non-issue. when we had, and I could talk about it later, but we had statutes. A statute was passed 2 years ago, the USA Freedom Act, that prohibited the government from holding the metadata in bulk. It didn't say anything about the private sector because everybody knew the private sector was going to keep it. But I would say, in support of your view, that one of the reasons why the European Court was concerned about the data retention was that the government would get access to it, right? There was the potential for government access under conditions that hadn't been specified. And that's where, well, I mean, I guess that's the lacuna from our perspective, is that conditions of government access to the data aren't the subject of a very well-developed body of case law, or legislation for that matter. The conditions under which the government, once the data is there and it's being held, the assumption is that for law enforcement purposes, they'll be able to get access to it, I think. So there was one other thing I was about to say on this. Well, maybe it'll come to me. It was basically, I guess, consistent with your point about the public sector availability is still a concern in the background. Maybe I should talk more about the way I see those differences playing out. One other thing I was going to mention, which is, and maybe again less concern to some of you, but one of the big issues with cross-border surveillance now is that even though the state surveillance has been enabled by technological development, it's also become inconvenient because UK law enforcement can no longer get access to a lot of data that it could have gotten in the past. For example, you have a ring of jewelry thieves operating here in Cambridge, stealing jewelry from stores and selling it in London or something like that. To investigate that crime, the UK ordinary police would like to get access to information that would be available on American servers, and they can't get it now, even though it concerns purely UK victims, perpetrators, etc. Now, some of that information wouldn't have existed 30 years ago. Some of it, an equivalent, might have existed in hard copies that they could have gotten here. Now they have to go through MLAT procedures, which take approximately 10 months on average to get access to information that's stored on American servers. So there's been a lot of law enforcement pressure in Europe to require data localization. And I mean, I don't know where that will go, but as of now, Safe Harbor allows a lot of transfer out. And many of the European countries are thinking about requiring at least that copies be retained within the EU so that law enforcement can get access to it, because as a practical matter, in order to get access to anything held within the US, a US ISP or Facebook is legally prohibited from responding to a UK law enforcement request, unless it's gotten the stamp of MLAT, which takes forever, and it has to be a judge and probable cause and all the rest of it. So there's pressure. So it's this factor is not so much in terms of intelligence gathering for national security purposes, but in terms of evidence gathering for law enforcement purposes, which means it has to be admissible in court. The globalization has created many headaches for law enforcement. One way around it is localization rules, which will be fiercely resisted by the private sector because it interferes with their business model. There's also a push within Europe for extraterritorial enforcement, which would be obliging UK managers to turn over information. which would put them at it would subject them to a conflicting rule. There was a case recently where a Microsoft executive was arrested in Brazil for not complying with a Brazilian demand for information. And then another possibility is just that they hack the information, which gives even less privacy protection. So from a law enforcement side, there's a need to streamline the process, but retaining safeguards that we would consider minimal safeguards.
And what law is it which requires this MLAT treaty?
Well, basically, the law is ordinary domestic U.S. law. It's basically the Stored Communications Act within the U.S., which makes it a crime for anyone to reveal categories of information, stored communications, basically. We have a 6-month rule. There's a very high, you need basically a search warrant, which can only be issued by a judge on probable cause, to get anything that's been in storage for less than 6 months. Once it's been storage beyond 6 months, you can get it with a subpoena, which is a lower standard, but it's still a court order. And those laws have been on the books for not forever, but since the 1980s, with no thought of international implications. I mean, it's a crime for you to do this. So when the Met from London shows up and says, "Give me, I'd really like to see this information," it's a felony for me to give it to you. So the only way you can get it is by a court order, but you can't. I'm saying now you're the Met. You can't go to an American judge and say, "Give me a court order." Do you guys work with MLAT at all? Or, it's Mutual Legal Assistance Treaty. It's the standard procedure for getting evidence from one country to another, and even MLAT was formulated in a world where a bloody shirt or a gun with fingerprints was sitting buried in someone's yard, and you needed it for a murder case in France, and you couldn't send the French cops over here to dig it up from the yard, so you follow the treaty. There are these bilateral treaties with virtually all countries. You follow the treaty. It goes to an office within the Department of Justice. It's an incredibly cumbersome process. I'm not sure why it needs to be so cumbersome. They say it takes an average of 10 months. And then the Department of Justice, presents it to a judge, and the judge will issue a search warrant. And all of that, was not great, but it was viable in a certain world. But it's not viable today when you're looking for a kidnap victim somewhere or something like that. So they want to have a system where the Met can go directly to the private ISP and file an appropriately documented demand for information. That takes legislation in the U.S. because it requires an amendment to the Stored Communications Act, basically. The bigger concern for most of us is the implications for privacy because of the various gaps that I mentioned. The fact that no country offers protection to non-citizens outside its own borders. And then number 2 is cooperation, where GCHQ can give NSA the information that it has on Americans, and NSA can give GCHQ the information that it has on Brits. So whatever, and what we would be concerned about, whatever protest movements there may be, or political dissent that's brewing, or whatever it may be, the Muslim imams who are preaching radical sermons and things like that, NSA can have a field day with that. No legal restrictions at all on the surveillance that they can conduct on people of that kind, Brits of that kind, and then just turn it over to GCHQ and vice versa. Even though it would be unthinkable, and the unthinkable has happened, I should use that advisedly, unthinkable for NSA to, engage in bulk collection of content on an American imam. Not even, it could be an Egyptian national if he's inside the United States. there's no way that they can legally engage in bulk collection of metadata or content. But they can do it for the guy in the UK and vice versa. So you have cooperation is a big breach in that wall. And then incidental collection becomes very interesting because in the American conception, in just an ordinary criminal investigation, let's say you're a drug kingpin. So I have probable cause. I get a judge to issue a warrant, very fully documented, and we have a lot of jurisprudence on what you need for probable cause, that he's a kingpin. I put a tap on his phone. Well, you're gonna hear everybody he talks to. That's considered incidental collection. And if the person he talks to admits to committing a crime, all of that's fair game to be used. So, because our conception is that you lost your privacy. You're the law-abiding citizen, as far as we know. You made that call. The FBI got to hear you talking. That's happened. It's spilled milk. And if in the course of that they see evidence of a crime that you're committing, they can use it because they've already intruded on your privacy. One of the big gaps in American law is that we don't have use restrictions. Once the government acquires information, the theory is that the invasion of privacy occurs when the information is acquired. It's a very flawed theory because the real rubber hits the road when it's used. But that's our theory. So once they get the information, there are no use restrictions. And that means that people who are accidentally overheard have their privacy exposed to a degree. It wasn't a big deal 30 years ago, but it's become an enormous deal now because so many people, because the worldwide communication has grown so exponentially that virtually everybody is in communication with other people. So what's the magic of incidental collection is that even our own NSA gets tons of information on Americans by targeting Europeans. And they can collect unlimited content, not just metadata, but content on Europeans. They probably have the complete text of all they could have the complete text of all your emails. So in the course of that, they have emails that you exchange with me. That's incidental collection. Plus, they can target people that they think are not Americans. Turns out they are, but that's accidental also. And they can target people of unknown nationality, which was not so much of a problem in the world of landlines. But now, with, as you guys know probably better than I do, you have an IP address. You don't know it doesn't come with a passport. You don't know the nationality. And unless they have reason to believe that it's a US person, they're free to, they're no longer subject. If it's not a US person or a foreign national within US borders, they have no restriction. So they can actually wind up collecting content on people who are US persons or people who are within US borders, but they didn't know it. If you take your laptop to a meeting in New York, you should be, even if, I assume you could still get in. I don't know what's happening now with immigration restrictions, but I don't think you need a visa even to enter the US from Britain. You come for a conference, you're only planning to stay 2 or 3 days. You are 100% protected by the Fourth Amendment. They can't break into your hotel room and read your files or grab your laptop and download the hard drive. They can't do that without probable cause and a warrant, even though they know that you're a UK person only here for 3 days. That would be unthinkable. But they can target your IP address of your computer. They don't know where it is. So they can say, well, we didn't know he was in the US. So then they can do it without any restriction whatsoever. So incidental collection then grows exponentially because it starts to involve not only accidentally overhearing U.S. persons, but also targeting people of unknown nationality or targeting people who turn out to be U.S. persons or turn out to be in U.S. territory unbeknownst to you. Whether we use a term U.S. persons, which means citizens or anyone who's admitted for permanent residency. So we, under our law, we can't discriminate between citizens and other people who are within the U.S. borders, or even permanent residents who are outside. So if we have Brits who have what we call green card, which is a permanent residency visa, they're fully protected by American law, even when they're anywhere else in the world. But conversely, anyone else who's not within U.S. borders is fair game. So you didn't give me time limits, and I've been going extemporaneously. The next question is, because of all this, the nature of this problem, what is the solution to it? And this is where it gets into international law, because many civil society groups have been urging that the solution to this problem needs to be some sort of an international convention or treaty. There's a group even called a Snowden Treaty. You can find it, I think, www.snowdentreaty.org, I guess. They're promoting an international agreement in which all signatory countries would establish rules for cross-border surveillance, would set uniform, privacy-centered, sensitive standards with no discrimination between the nationals of their own nationals and those of other countries. And that seems like a logical way to deal with this. And I thought it was very ironic to think about, coming to talk about this at the Lauterpacht Center, because I'm sure that in the world, in Professor Lauterpacht's world, this is how you would approach this sort of a problem. And it feels kind of churlish for me to say that this is the wrong way to go and to be saying it here at the Lauterpacht Center. But I think it's interesting, if I'm right, how much the world of international negotiation and international human rights has changed from the world of his day. Because, and in this regard, I found myself at the conference out of which this book grew, and it was this kind of thing, as you know, we invited some government security people, national security people, and they participated. But as you know, this kind of a conference is all people from the left or people from the human rights side of the equation. Everybody outdoing each other in how committed they were to the right to privacy. Many of them my friends, and obviously I'm sympathetic to the idea of trying to solve this problem. But when I started to think through what it would mean to have a multilateral negotiation to solve this problem, I was horrified. Because I have no doubt that type of a negotiation would be dominated 100% by the security services. It's also true, and this was said in critique of my paper, that the security services have a lot of clout in the legislative process also. And the courts defer to them a lot also. But in an international treaty negotiation, they have 100% control. No other civil society groups have any leverage to push back against what they might do. Whereas in legislation, you have the Silicon Valley has a lot of clout. The civil liberties groups have a lot of clout. The ACLU doesn't have much clout when it comes to Guantanamo detainees, but when it comes to electronic surveillance, there are powerful civil liberties interest groups, because this is a middle class issue that members of Congress respond to. in a way that's unheard of when the ACLU talks about the death penalty or things like that. So my sense of comparing the dynamics of the legislative process versus international treaty negotiation led me to think that the dynamics now are kind of have turned upside down what it was in the world of Professor Lauterpacht in the 1940s. And that the way you get effective safeguards for privacy today is to have it cashed out in a forum where the private sector, corporations, and the civil liberties groups have a strong voice and a leverage to push back against the intelligence community. And in the American setting, the private corporations, excuse me, I don't know if this is different from the European perspective or not, but in the American context, the private corporations have been very strong advocates of privacy protection vis-a-vis the government. Not in terms of their business model for retaining the data and slicing it and dicing it in every which way they want, but they're very concerned about the migration of data processing and storage, cloud storage and things like that, migration from the US to other countries that can offer more protection, whether it be Iceland or Ireland or something like that. So it can be kind of like a tax haven for data processing. And Silicon Valley is very nervous about that. So they want to be able to assure their foreign business customers that data that's held in the US is going to be very tightly safeguarded as against government spying, which they can do now, and could only do with great difficulty if you have a multinational norm that's the same everywhere, because then they don't care how high or low it is as long as nobody can beat them. So that's something that's played out to our great advantage in the US. That in terms of the USA Freedom Act and some of the other things, Silicon Valley was a very effective lobbyist for saying we've got to keep the wall against government intrusion very strong vis-a-vis the government. So that was that. One of the, should I take 5 minutes or how are we doing?
I think five minutes is fine, but then we'll have the
Not
discussion
beyond
there.
that. Okay, sure. The one thing I've sort of talked about implicitly, but to underscore some of the ways that I think U.S., for all the shared values between the U.S. and the U.K. and the U.S. and European Court of Human Rights, if you will, many of our approaches to privacy are somewhat the reverse. I've talked already about a lot of that in terms of our preoccupation with the government. But the U.S. law focuses in a way that I don't see in European law. Number one, individualized judicial approval ex ante for any peek at content, just as an absolute prerequisite. Our conception of probable cause, our conception of independent judicial approval, and our insistence on ex ante rather than ex post review is really hardwired. Secondly, that we have very little difference between ordinary law enforcement investigation and national security standards. As long as you're talking about our own citizens or U.S. persons within our borders, for what you could call domestic national security, in other words, terrorists who don't have any connection to a foreign power, the standards are identical. You absolutely cannot, even if you say it's a national security objective, let's say an American imam, you still have to have probable cause and a warrant ex ante, etc. For national security that has an international dimension, the standards are slightly different, but they're very I couldn't even begin to talk about. They're very detailed and very specific. And that's where I see, that's why I look at this and I say there isn't such a preoccupation. The court talks about access and so on, but there doesn't seem to be a very strongly developed body of law that says, what does GCHQ need to do in order to surveil? I think you have now an Investigatory Powers Act, a new one, but it keeps changing, and you guys probably know more than I do, but this IPA, I guess, 2016, has standards for GCHQ and other authorities, but it doesn't require ex-ante approval, it doesn't require judicial review, it doesn't require probable cause in our sense. It doesn't have to be targeted at individuals. I think you allow what we would call thematic warrants. Do you guys know what those are? This is a British concept, but we would have to have probable cause to believe that a particular individual is committing a crime. The British warrant under the IPA allows you could target people who might be involved in human trafficking. So if you had probable cause to believe that human trafficking would be involved, that's what we would call it, or you guys call a thematic warrant. So it's not a warrant that David Erdos is probably committing a crime, which is what you would need to get a warrant against him under U.S. law. What you need to be is that people who come to workshops at the Lauterpacht Center are probably discussing crimes, or might be. In the UK conception, I think just articulable reason to think that people who come to seminars here might be discussing crimes. Then they could put a bug, whatever, to tap everybody. So it's not targeted, even under the IPA. And then if you look at German law, I don't know. And again, I think it's lax by our standards. French law certainly is almost non-existent when it comes to national security. And that's why I think the European Court of Justice, for all of its celebrated jurisprudence in this area, has never come to grips with the scope of government powers in the national security area. It's always dealt with the cases involve indiscriminate collection, and they've always said there's a lack of necessity and proportionality because it lumps together national security purposes and any other purposes that might be involved. So they've implicitly, I think, left that potentially when the purpose is national security, I think the court would be very likely to allow a very wide margin of appreciation for surveillance or investigatory powers that are targeted specifically at national security. Then they would be likely to say there was proportionality and necessity for rather wide, rather flexible, rather opaque powers. Whereas in the US, the Foreign Intelligence Surveillance Act is very specific on the assumption that it is foreign intelligence surveillance, still very specific and requiring probable cause. So I think that's all I should say for the time being.